whenever company A assigns a trademark to company B, the assignment language always covers the goodwill. Like, you never want to be moving trademarks without the goodwill attached.
Welcome to a brand new episode of the M&A Mastermind podcast presented by Cornerstone International Alliance. I'm your host, Nick Olsen. On this show, I get the opportunity to talk with the brightest minds in lower middle market M&A. Together, we discuss industry intelligence, deal management, shared successes, specialized expertise, and much more. If you serve the small to medium-sized business owner, this show will offer you tactics and insights you can use and implement now to become a master in M&A. Hi, everybody. Welcome to a brand new episode of the M&A Mastermind podcast. My guest today has over 20 years of experience in corporate law. She serves as legal counsel for entrepreneurs, business leaders, and investors. Her passion lies in helping businesses with uniquely valuable intellectual property. She's worked for boutique law firms, nonprofits, and recently joined Frankfurt, Kernick, Klein, and Sells. Please welcome my guest today, Wendy Howe. But Wendy, how you doing today?
I'm great, Nick. Thanks for having me on. Looking forward to our conversation.
Yeah, likewise. I'm very excited to have you on here today. And I've only had one other attorney on my show today. So great to have you. As you know, you guys play a very important role in the exit of a sale and just growing the value of the businesses and all the things that we do with our business owner clients. So really excited to have you on the show today, dive into the conversation about intellectual property and goodwill, and all the things that business owners and M&A advisors should know and need to know about that when they're looking to exit a company, and just making sure they're covering all their bases. So to kick off, tell us about your background and what your focus is for your practice.
Sure. I started my legal career at a huge mega global law firm in the IP group, but doing transactional work. So I always think of myself as a corporate lawyer who's trained in IP. So I really love the marriage of the two. It sometimes makes for a hard sort of elevator pitch, but the deals I love working on and the things I like doing the most are where you're looking at both of these elements of a company, and particularly as it's building value and growing and going through major strategic changes, or whether it's an exit, an acquisition, growth strategies, things like that. From there, I spent a little time outside of law. I worked at a startup, I ran a nonprofit, had my kids, did a few other things, and then went back into law in a more boutique practice, eventually running my own firm for a while. And now I'm sort of maybe having a Goldilocks moment at a mid-sized firm, where I'm in the corporate department of a very IP strong firm that focuses a lot on brand building and entertainment and media, communications, advertising, IP of all sort of stripes and sizes. And I sit in the corporate group there.
Thank you for that. And I think you're very much positioned to talk about our topic today. Like I said, intellectual property and goodwill and how it can affect a business owner. So like I said, we're talking about that. We're talking about building that moat around your IP. And what if, and what is what are the different, so to kind of start, like, you build this moat around IP, right? Well, what is IP?
Yeah.
You want to tell our listeners, what intellectual property means, and all the different maybe forms of it?
Sure. Yeah. So I love this idea of a moat because it's very hard to build an impenetrable wall around your IP. And they're kind of one and the same, right? So when you think about what your IP is, and you also try to think about how to protect it, it's kind of the same thing. Sort of, I like to say anything protectable is your IP, and anything that's your IP is probably worth protecting. So there's the traditional buckets we kind of all know of: trademarks, which refer to brands and slogans, logos, anything that can designate a source of origin. So if you see something like, behind you, the logo and the brand, like that tells me where this material is coming from. It's coming from, this is the source. That's a trademark. Then there's copyright, which is a little harder to understand, but still something we have a good concept for. It's anything that's into a fixed medium. So the recording of this podcast is a copyright. The lyrics to a song are a copyright. The notes for a choreography are a copyright. Then you have patents, which is also something that we generally understand pretty well. There can be formulas, there can be technologies, there can be any number of design patents. There's a lot of areas within patents. So those are sort of the three most traditional. Then there's something called trade secrets, which is also a very popular right now. And that's basically anything you keep as a secret. And that if you work at a 2,000 person company, it can't be something that everybody knows. There's some famous trade secrets, the KFC recipe or the Coca-Cola recipe. These are trade secrets. The Google algorithm, the formula for the post-it sticky notes. So these are things that maybe also have other protections around them, but are held in such a way that very few people know them. And the idea that anyone would learn them would mean they've somehow breached your trade secret. So a lot of companies are using those now for their technologies and things like that that are sort of elusive, that those other traditional categories don't protect. And then beyond that, yeah, go ahead. You're gonna have a question.
No, I was going to ask the question on trade secrets. Like, how is that one more difficult to say this is a real trade secret than, this is a patent or whatever? And how do you really kind of hone that in and make sure that it's protected?
Yeah, it's a tricky one, and a lot of the protection is done sort of not in a legal way, if you will. So, for example, if you have a company and you believe that there's something that's a trade secret within your company, and let's say it's a small company, you've got 40 people working at the company, and there's something that you believe is a trade secret. Maybe it's an algorithm you built or some special way you maintain your relationships with your clients, or something that's like very, very unique and different that you've really come up with and you feel it's trade secret protectable. You really have to just make sure you're protecting it as a trade secret. So you're keeping that behind sort of lock and key. So only a few select people have access to that material. It's only used in these certain ways. And then the idea is that anytime somebody else does it or uses it, they've by definition infringed the trade secret. It's a little bit funny, and it's sometimes a little hard to believe this is actually how it works. But so let's say that 40-person company, somebody leaves that had access to the trade secret, sets up their own business very clearly using your trade secret. So merely the fact that they are using your trade secret would mean they've infringed on your trade secret, because it's a trade secret and they're using it to they have to be creating value for their company. So they've started a company, right. They're using your trade secret. And you have to show that they had access to it. And this was a person that worked at your company, they had access. I've seen some cases, like a real world example was a client that had a technology platform, and another company had shown the CEO of this company their back end because there was a potential like joint project that was going to happen. My client then went on to grow their business, not utilizing that company's IP whatsoever, but that company came at them and said, hey, this is our trade secret because the fact that you've been able to grow. Now, the company that claimed my client was breaching their trade secret didn't have any proof, didn't have access to my client's back end. And we went back and forth for months on them trying to get access to the back end in order to prove trade secret infringement. That went into the courts, litigators handled it, everything's been settled and is done, and my client, is in the clear. But that's sort of a real life example where.
Very interesting.
Yeah, that happened.
Yeah,
yeah.
I think there could be a lot of gray area in that.
There is a lot of gray area. And the challenge becomes, one, how are you really, like in that example, if we'd really gotten to a point where they were making a stronger case, then you say, well, why did you give this person access to your trade secret? This person, to me, falls outside the circle of who should be getting access to your trade secret. And then beyond sort of those 4 buckets of IP is where the moat comes in my opinion. And sometimes that's really simple stuff, like how people are engaging with your platform or your technology or your service. Are the contracts buttoned up such that they know this is your IP? They know this is something that you own? Sometimes it's hard to protect things. You can't protect sort of your ideas, your concepts, but first to market, is that an IP concept? No, but to me, that's a way to gain value from your IP. So if you've created something really awesome, get it out there in the world, start to have brand recognition and start to build value by being first at market. Certainly, the way you interact with folks. If you're offering something online, let's say you wanted this podcast, to be your proprietary material as it is, it's just making sure people know this recording belongs to you. This isn't something that folks can, copy and claim as their own. Yeah. So that's where the moat comes in my opinion, is these conversations where we start seeing where are the little places that you can continue to protect and build and own what you're working on.
Yeah. Are there like any common misconceptions about IP, whether, some people think they have it, they don't have it, or just, what are some things that you see time and time again that maybe people just don't quite understand it?
Yeah. 2 things come to mind. One is protecting technology, and I'll get to that second. And the other is just kind of this idea that they can own their ideas. So I've seen a lot of situations where it's either founders, or it's sometimes after a founder split or in the process of a founder split, or it can come, later down the road, where somebody wants to take ownership over something that was just merely an idea. The IP laws of this country are pretty clear that you can't own your ideas. So if you and I go into business and I think I came up with the winning idea and turns into this great business, but there was no protectable IP there, there's really no protectable IP there. Software technology is another really tricky one, especially these days, because it's really hard to prove that that's so novel to be patentable. And you can file copyrights on software technology, but people are changing the code, and the technology is changing so quickly for the most part that it's really hard to keep that protected. So that's where you sometimes see trade secrets coming in for some of these larger platforms, or any size platform for that matter. But yeah, those are two that immediately pop into mind, but I'll think of others as we keep
Yeah.
talking.
Yeah, absolutely. So goodwill is a thing. And
Mm-hmm.
first, I guess start out by what is your definition of goodwill, and how does that impact your intellectual property?
Yeah, I mean, so goodwill kind of gets a little bit to this like gray area, right? The sort of in between, because we think of any brand and it's hard to value the brand, but there's this concept of goodwill, right? You walk into a grocery store, you see that this was made by Kraft. Well, you assume it's gone through a certain amount of testing. You assume it's not using certain types of ingredients, things like that. That starts to be the goodwill around these brands. And it's really easy to understand goodwill, I think, in that context where you're thinking about a trademark. Whenever Company A assigns a trademark to Company B, the assignment language always covers the goodwill. Like you never want to be moving trademarks without the goodwill attached. If you're on the receiving end, make sure that the goodwill is attached, because that's a lot of the brand value is the goodwill. So the definition that I use for goodwill, I would say it's a little bit fuzzy, right? But it's this idea of what we associate with it. If there's a certain, studio, movie studio, like oh, that studio makes action films. So there's like this sort of goodwill around it that's probably going to be a fun action film I'm going to enjoy. Or we were talking about sports earlier, Nick, and it's like there's a lot of goodwill around sports brands. So we're really inclined to have allegiance to them, and it invokes a lot more in us than just like the name of our sports team. There's a lot of goodwill built around those brands. It's something that, if you're firing your coaches or not firing your coaches, that's going to impact how people might start feeling about your brand. That one, there's a lot of loyalty, so those don't always make folks think differently, but it can. So I think that's a good way to sort of think about it. Goodwill tends to be sort of the public association with your brand when you're thinking about it around the trademark and around the brand value.
So goodwill obviously impacts, company value in certain ways. Do you have is there an example that may come to mind about how in a situation, maybe with a client or a transaction you worked on, that goodwill, positively impacted, the value of a company?
Sure. This one's maybe more tied just to straight IP, but I think the goodwill comes into play really largely here. I had a client who wanted to sell their business. It was an apparel business in sort of the sports, in a particular sort of sports arena. And yeah, like a small acquisition. And the original discussions didn't involve a really high multiple. Like it was just, the founder was pretty disappointed with, they felt confident about this buyer, but as the numbers started to go back and forth, felt a little dismayed. And one of the conversations I had with the founder was, well, are they aware of what you've built from a goodwill and a brand perspective? Like, have you put that out there and had that discussion with them? Have you shown them, what your, everything from like, comments that had been made on their, social media posts or emails they'd gotten from customers, the customer loyalty, the brand loyalty that they built, the brand awareness they built, the trademarks that had been protected. And then the founder went back to the prospective buyer with this, and suddenly the buyer did see the value of this as an entire brand, as an entire package with the, the protections that had gone into place around the brand and the other assets, and therefore building up that goodwill and customer loyalties. And the number went a lot higher after that conversation, which was great, and got the founder the exit that she was really more excited about. So that's one.
Did this particular client have an M&A advisory firm representing them?
They didn't. They didn't.
Okay.
But yeah, good to know, because I think that's something that probably an advisor would have brought. I mean, sometimes my clients are small enough that an M&A advisory firm may or may not be, but I think those conversations are so helpful regardless, right, of size, and at least get the conversation under your belt, and then the advisor can decide. Because sometimes I think the advisor can find more value than maybe the founder thinks is there, than the lawyer might know. So those conversations, I think, are really important at that stage.
Right. And yeah, I mean, everybody plays a role and has a place in the process. And your conversation with them, your client saying, hey, think about this because that's your area of expertise was, essentially, probably got them more money out of the deal. And, like I said, as an M&A advisor, like you would want to bring in someone like yourself into the equation and say, hey, are we thinking about this appropriately with this IP and this goodwill? And then they can go and out and see what value can be out there for it. But it's good that you brought brought that to the client's attention, because
one thing that brings up, Nick, too, is like, and something I think about a lot, and I'm sure you're thinking about all the time, is having these conversations earlier. So if a client says to me, hey, we're thinking about going through a process next year, great, let's talk now. Let's give ourselves a nice runway so we get everything set up, whatever that means. That literally might be, let's maximize some contracts so you can just have a little more value built up over the next 6 months, or talking about let's make sure the IP is dialed down. I'm sure there's a million things you're always thinking about. But that's something that I find there's so much education there, which I love that, you have podcasts and stuff where you're helping educate folks on this. But it's like these conversations can be way more helpful if you're given a little runway than like, hey, we're at the end of our, we gotta sell because XYZ is happening and we're looking for a deal in the next 3 months or 2 months or whatever.
Right. It happens all the time. Business owner wants to sell now, but numbers just don't add up, or, certain things aren't taking, like, and so that kind of leads me to my next question. When you're thinking about IP, let's talk about, obviously, I want to go back to, preparing and having that runway.
Yeah.
But
Yeah.
let's say they don't. What are some things that, you're doing, working with your clients on, maybe in a short period of time, that you're doing to maybe protect whatever IP, assets they have in their portfolio? Like, what are some things you can do, in a short period of time to make sure those are covered, obviously? And then after that, I want to get into like, hey, let's prepare ahead of time and how we can prevent this from happening.
Yeah. Well, it's so different with every company, right? So there's not necessarily like, this is the playbook, but I think that we can give some tangible takeaways here, which is there's, go back to those initial sort of buckets. Like, are you maximizing those sort of patent, trademark, copyright, things that you can actually put on a schedule, right? On a deal schedule or in a data room, you can say, hey, here are the actual tangible IP assets we have. And then there's also just the practices you've put into place around protecting your IP. So some of those, like I said, so if you're I have clients who are doing, maybe it's a SaaS platform. So what's everyone engaging in when they join your platform that acknowledges that this is your proprietary software, that you own everything that's built here? Again, depending upon the business, sometimes there's somebody who's performing deliverables for someone else. So like I have a fintech company that performs deliverables for their clients, and part of those deliverables are reports, and the reports can be in the form of a PDF daily, whatever it might be. So we spent a long time going through, how can we make sure that these reports and the deliverables that you prepare for these clients don't belong to the clients? Because there was some concern at one point that this stuff could be kind of reverse engineered, and maybe these end users could figure out how to kind of, at least some of the financial reporting could be obtained in other means. So that could be, it's not a tangible IP, but that's a really big piece of the IP that when you go out to investors or to go through an M&A process, you can say, hey, here's what we do. And you have a really clear action plan on what you've done as a company to protect that and make sure that if you find yourself in a situation like that, or you won't find yourself in a situation where a client's claiming ownership over that, because you've put that clearly in the contracts and in your day-to-day practice, and that everyone from the customer service people on up know how to respond to, queries or questions. Hey, can I get the Word version of this? Well, the answer is no. Whatever it might be that you've really put into place to protect something you're building.
How much stress from your perspective does that add when, your client, comes to you and they don't know what IP they have, if they own it, if someone else owns it? Like, I got to imagine it's a bit stressful.
I mean, I guess it's the nature of the beast. There's being in private practice, I have lots of different clients versus if I worked at a company and had, one client. So there's a beauty to that, which is, their problems are kind of their problems. I don't have to go to bed thinking about them. But then also, I really care about my clients and I become passionate about their businesses. So of course it does. I think I like the puzzles, right? So it's not necessarily stressful. What I find, I guess, stressful is when somebody doesn't seem willing to do the work, or kind of doesn't get it, or doesn't come to the table with the right pieces, or isn't willing to bring me the pieces to kind of wrap our heads around the puzzle. I mean, the examples I've been using, have been the great ones where the clients have been really enthusiastic about figuring out how do they, create something and own it and monetize it. But sure, there's I'm sure I could sit here and go down my pity party of the ones who, coulda, woulda, shoulda. But we try not to focus on those, right?
This episode of the M&A Mastermind podcast is powered by Cornerstone International Alliance, where leading M&A firms come together. As part of this international network, you get access to global opportunities, over 200 M&A experts, enhanced collaboration and knowledge sharing, and some of the best M&A tools and resources available, all to help you take your firm to the next level. Ready to join this exclusive network? Visit cornerstoneia.com/new member today. Well, so from a planning perspective, what are some maybe some guidance or steps that you would give business owners out there listening to make sure that their IP portfolio is properly, like, maybe documented, understood, and, another big part, especially in a transaction, is that it's transferable to the next buyer.
Totally. That's huge. And that it can show up as valuable and transferable.
Yeah, right.
And that it is transferred. I will say this is just like word to the wise. If you are acquiring through an M&A process and you are getting IP, make sure you have proper counsel, get all that IP assigned to you formally as soon as possible. I have a client where we are spending so much time because they were acquiring brands all over the world for years. They're now kind of selling some of these brands. I only became counsel this year, and we are spending so much time tracking things that happened 5, 6, 7 years ago that were never recorded in China, in South Korea, like all over the world. And we have folks that sold us that IP who we're now trying to track down, trying to convince them to help us out. Some of them are giving us big fights because they're kind of like, why is this happening now? And it's just time consuming and costly. So that's just word to the wise. Yeah. When you're on the other end and you've made the acquisition, get that stuff buttoned up. Doesn't have to be the day after, but you have a good grace period of a couple months for those post-closing deliverables, but be conscientious and have good counsel help you get those organized. Because then when you turn to sell the business later, you're going to need to prove clear your chain of title back to you so you can sell the assets.
Yeah.
But anyway, yeah. So, but to answer your question, it really starts early, right? It starts thinking from day one. What are your goals? What are you building? What do you want to protect? What do you want to own? That's going to pivot and that's going to change and that's going to take on new forms and shapes. But at each turn, thinking it through, like I helped a company, a media and sort of ed tech company sell to Scholastic, which was a super exciting sale. And it was a big, sale. And we had done a lot of IP protection on the front end. And it was great because when they were able to go to Scholastic with it, they had a whole stack of registered copyrights and a whole suite of registered trademarks, and that they could say, hey, look, this isn't just some workbooks for kids. This is something that is a brand that can turn into stuffed animals and can turn into pajamas and all the things that a Scholastic would want to monetize out of an educational technology platform. Because we registered trademarks for all of these areas, which isn't always the case. So this company is now building their next business, and we've been really, really proactive about registering things pretty aggressively so that they have a beautiful packaged product to go sell to whoever wants to buy it. So I think but it depends on your goals, right? There'll be a lot of companies where I'd say register the house brand trademark and don't go crazy. It's what are your goals and where do you see this going, either for yourself or for your acquirer? And if the plan is to run it as a house brand for some period of time, you have a long runway. But if it's, hey, I want to build this and my goal is to sell in 5 years or whatever, you might be anticipating what the goals of that acquirer is. Hey, I want them to be able to register this. Like I want this to be a global brand. I'm not going to do that, but I wanted to sell it to somebody who can turn it into a global brand. Well, you know what? We might want to do some clearance in some of these major jurisdictions and get some proactive trademarks registered, because some countries are what's called first to file, which means like in China, somebody can file a trademark for your brand even if they're never offering the service. So even if you don't plan to run business in China, if you're a consumer-facing brand and you want to sell to Unilever or whoever, like they're going to want to turn on that global market. And it might be worth proactively getting a registration in some of the countries that are really known for squatters. And that's just one example, right? So, but it really depends on the goals and where you're trying to go with your business.
That's great advice. I love this, even from the buyer perspective. Like, make sure what you're buying is actually yours.
Totally. And from the buyer perspective, exactly. And I love when I help with the diligence, because then again, you really need to know your goals. If your goals are to, hey, this is a Vermont-based IT consultancy, and I'm buying it to roll up with these three other IT consultancies. Okay, well, what are we thinking about here? Do you want to run it under one brand? Do they have it's just going to depend on the business and what the goals are. But is there some proprietary technology that we want to make sure they protected? But it's not just for them, it can grow, and that the IP that was built by an employee is owned by the company. I mean, that's another really important piece that I'll throw out there is, and I think this was something we were going to talk about too, is like, if you're building a company with the support of anyone, which almost always is the case, whether they're in-house or an external vendor, is to make sure that that IP and the goodwill surrounding it benefits the company and not whoever, I've seen, unfortunately, like white label vendor contracts where the vendor owns the IP they're building for you. Now, they might own the underlying white label, but you need to be able to own whatever's been layered on top of that.
Yeah. I would imagine that's a pretty common mistake on the business owner's part when you're working with contractors or third-party people helping you develop or build or,
Yep.
whatever.
Yep. It's very, very common. And even with your own employees, people come and go, or you maybe have somebody that's like a part-time person that comes and then leaves, and you want to make sure that you own the IP, because that's something that from either side, right? So if you're a buyer, you want to check for all that. And I've definitely been in situations where we're the buyer or an investor, and we've forced the company to go track those folks down. Co-founder that left the company 5 years ago, let's make sure we track down their documents, and that can be really painful later. So if you're having all this stuff, right? It's like so much easier if you do it early. So if you're having somebody's leaving the company, make sure that whatever they sign, it's worth a little money or a little equity at that time to make sure they sign everything for you, so you have a really clean ownership of everything. I always think of the company as the bucket, right? And you want the bucket to hold everything. Nobody should hold anything else. Everything should be in the bucket. Even the founder, everything should be in that bucket. And the founder owns a piece of the bucket, and everyone owns pieces of the bucket, but the bucket needs to own all the IP.
Yeah, because when the owner leaves, then if they're taking some of those components in that bucket, then obviously that's taking away part of the company, but also diminishes the value.
Totally. And it's not holistic, right? The bucket can
Right.
get, yeah.
The concept of, I guess, hidden IP or this kind of thing is maybe things that are out there attached to your business that you as the business owner know about, but don't necessarily know about. It's your IP. It's the thing. It's what you own. Like, how do you approach uncovering with a client? And I'll take this one step further. Let's say you're an M&A advisor. You don't have with someone like yourself in the mix yet. If you don't get someone like yourself in the mix, right? But if you don't, how are you strategizing, your analysis of your client's IP, but also like making sure you're uncovering all the things that they don't necessarily, know about?
Totally. It's a good question. I guess I would start with sort of those four buckets. So interestingly, for trademarks, for example, there's a concept of a common law trademark, and that builds goodwill. So even if somebody hasn't registered a trademark, they're still building value around it as a common law trademark, because the laws in this country are first to use, not first to file like in China. So you start earning rights even before you register, or if you don't register. So I think maybe they start with that sort of like, okay, is there anything that, is a common law? Or maybe you're just saying, what are the trademarks and what's the goodwill around that, registered or unregistered? What's the technology or the patentable anything here? Is there anything here that's worth patenting? Because with patenting, you can also do a provisional, which, while that doesn't show the same value as an actual patent, so a provisional just really in short is, the joke is you could file a napkin, you could write something on a napkin, stick it in the mail and send to the trademark office or the patent office. I mean, theoretically, because they don't review them. Provisionals aren't reviewed. You're just given that protection for a year. It's essentially like stopping the clock. So you have a year to get a full-on patent on. And there's some complications around it if the patent has already been published, et cetera, et cetera. But there's something there potentially like, hey, let's put this provisional in. That's something we can tell a seller about. And that could be a buyer. That could be valuable to a buyer. So if I'm an advisor, I might be thinking about, do we want to, throw something in on a provisional, because certainly that can increase value big time. I've seen huge multiples for things that are either patented or obviously could be patented. With copyright, it's a little different. I mean, you can throw some copyright applications in. I don't know that those necessarily increase value tremendously, but I think that's a place to start when you're thinking about IP. And then beyond that, you're going to start when you said this sort of like hidden IP, like what do we not know about? I would look to sort of your value in the marketplace. Start looking at, is this a consumer facing business? Therefore, what do consumers see here? What is the value here that we bring? What's our value proposition to our consumers? Do we have social media accounts that have huge followings? That can be tremendous, right? Especially depending on who the buyer is, to be able to exploit a following. That's could be great. Do we have loyalty from our customers? If we're a B2B, what does our business customer say about us? Like how are we positioned in the market? How are we recognized and appreciated? That starts to go to that goodwill. And so maybe there's a little bit of I've had clients have consultants talk to their customers and their clients and sort of get some testimonials, and that can be great for proving some goodwill and potentially help package up the company, right? Like you're looking at how can you package this company? I think that can really help. Hey, we only have this many customers, but they're going to repeat every year because they're so happy. So this is ARR that maybe you don't see as ARR because our contract system isn't set up correctly or whatever it might be. But, things like that, I guess I would be starting to think about.
Yeah. And how can advisors, like I said, transaction or even, as you're valuing the company or during the process, like how can they help build that moat around the stuff that protects their clients and, in the same breath, attracts, more buyers out there?
Yeah, totally. I'll quickly say, I also find from a legal perspective before, whether it's an M&A or I've seen this with joint ventures too, is sometimes there's a lot of homework that lawyers need to do, corporate cleanup, that can really help move a deal forward, right? And prevent too much deal fatigue if things are a bit messy, or just show a better data room and therefore tell a better story and therefore get a more excited buyer. So I'll just put a plug in just for the corporate hygiene too, whether that means tracking folks down or reorganizing sometimes. I mean, I had a project we worked on this year. It wrapped in July, but it was over a year for a joint venture. This was a media company, and the other side was Kendrick Lamar. So it was like a very exciting, big name, big project. But we spent more than half the time, like we knew that was on the horizon, but we spent, 8 or 9 months just working on some back end stuff for the company, like buying out a different investor, getting the company reorganized in a way that it could be ready for that transaction. So it's not an M&A, but I think of them similarly, right? Like you need to be ready for somebody to come in and want to basically invest in you and create this joint business with you and put their name, with yours. So that's not even the IP piece. A lot of that ties into the IP, but not necessarily. So but to go back to your question, which was, sorry, the question was about just helping
the moat. Like how can the advisor help the moat?
Yeah.
Like I said, I do completely agree with you that bring in an expert like yourself or an M&A attorney or attorney who's experienced in IP, that they can help you with this process.
Yep.
But just some tips that if they're gonna do it, on their own or just try to help their client out here, like what are some strategies or things that they should know to make sure that moat is protecting them?
Yeah. So let's imagine we're talking about the process between kind of the M&A advisor getting involved and let's say term sheet, right? So when sometimes like I've been brought in kind of post term sheet sometimes because the advisor might help get that term sheet signed up and then it's like, okay, now we want to spend money on the lawyers. Sure. Mm-hmm. So I think a piece there is, when you get to that term sheet conversation, that you can adequately present the company's IP. So if we're tracking back for that window that you're asking about, okay, so starting with sort of those 4 buckets. But then I think, and I'm not an advisor, obviously, so it's not my area, but I'm sure one of the big questions is, how are we packaging this up? Like, what's the story behind this company and why it should be attractive, and who are we looking, and that's therefore picking who are our buyers. So telling that story via IP. So telling that story in like, what do you need to own? Okay, this is a soda company. Let's think of what's the company, Poppy, that was acquired for some insane amount of money with a B attached to it. So when somebody was packaging that up, they said, okay, this is a healthy soda that can go global, All right, so what do you need in order to tell that story? And some of it will be obvious. Okay, you need to make sure the trademark is protected, like we were saying, these different countries, blah, blah, blah. The formula, okay, is the formula trade secret protected? Is it protectable in some other way? What's unique about it? Okay, what's our brand loyalty story? How many markets are we in? So I think it's just, again, it's sort of thinking about all those possible areas. But I always like to start with the goals and sort of the story, like where are we going, who are we trying to sell for? And then you kind of back into that and say, well, what is required to tell this story? What needs to be buttoned up? And that's a brand story. So if I'm packaging a a B2B IT company, right? Like we were talking about, okay, what's the story that I need to tell for this to be appealing to some, private equity team that wants, another IT services company under their belt, and backing in around that. Okay, that they have their systems in place. They're in a great journey, they're in a location where they're one of the few players in this space. Okay, what does that mean? Can we have some sort of ownership around that, or our processes are really smooth the way that we market to our clients, and we've built this great interface that's super clean and simple. That might not be protectable IP, but that's something to make sure that it's, the way clients sign on to it, they recognize they're signing on to something that you own, things like that.
Are there any like common questions you'll ask just to kind of uncover those things, or you're talking about some of those things outside the four buckets, because the four main things are the four main things you should just always ask those questions, but to uncover things you may not know, or are there any leading questions that you typically ask just to discover what else is out there?
I think a lot of it goes to, how are you engaging with your customer? Like, what's your customer? How's your customer engaging with your brand, or you're not brand, but I'm not talking about brand here. I'm talking about your business. So again, let's say it's a tech platform, let's go back to the fintech company I was talking about. So what's the process that they're engaging with your service? Are they going through a contract process where they're signing a contract? Is it like a shrink wrap? Are they signing on something? And then kind of looking at that and recognizing, what do we own? What is the engagement process there? Obviously, you can see the numbers. So you see, the M&A advisors looking at the numbers, like what are they paying each year? Is this an automatic renewal? But I tend to look at a lot of those things. Again, these aren't necessarily IP, but it does help build that brand story a little bit of this is why this is such a valuable company, and there should be a high multiple for it, because it's got built-in protections that are going to create relationships year after year after year. If it's more of a B2C, maybe you're looking at some of those customer, relationships and what brings people back. How many times do customers come back to you for the service, and why, and what keeps them loyal to your brand or your business? Yeah, I think it's uncovering. I mean, that would probably be where I would start. Yeah, uncovering that story. And what's that?
That's
What
good
are
advice.
the pieces? Yeah.
Look at how your customer views you, your process, how they get to you, and how they spend money with you, and just kind of unpack the whole process. I think that's really good advice. Last question, Wendy, this has been amazing. Are there any trends out there in the world that around IP and value, or even Goodwill, that our listeners should know about, or things that you see on the horizon as it relates to IP?
Yeah, well, I don't think it would be an appropriate November 2025 conversation if we didn't talk about AI. So I will say it's obviously everywhere. And I don't know that there's a piece that's a quick packageable little takeaway, but definitely think about it, right? Everyone's enamored. Is there a bubble? We don't know. Like, what happens next year? We don't know. But certainly right in the here and now. So I would think about, depending upon what your runway is towards the process, you might not be saying, hey, build an AI, part of your business. I'm not advising that, but try to uncover how they're using it. So even if your customers or your client is using AI simply as like a way to draft communications, like not everyone, but I'm guessing that most folks are using it in some small way. And I think showing that there's some element built into the business that can be exploited or that can be increased, I think is a net positive generally. And the way that buyers and investors are seeing it as a net positive, that's what I'm hearing. And I'm hearing a lot of clients have a hard time getting engagement if there's not some element of AI built in. So as an advisor, I would sort of poke that, hole a little bit and just find out anything you can. And you can kind of say, personally, I think AI is a fantastic tool, and I think we're going to see so much development. But I also think there's an element where it's like a website, right? It's like, of course, there's AI that's going to be part of everything we do. So most likely there is some way that somebody's using AI. And I think if you can put that in some of your, again, when you're packaging this story, that AI is utilized in this, that, or the other way. Maybe it's just used to, slice and dice customer data, or it's used by the founder in, drafting copy for the website. I mean, whatever it is, it's like, there's got to be something. And I think that's a good piece to just make sure you're kind of checking that box and incorporating that into your story.
Yeah. Like anything in the world today, artificial intelligence needs to be talked about, considered, and not forgotten about.
Totally. And I'm hearing folks like, I'm here in New York, so there's a lot of people in my world that work in big financial institutions. And I've heard multiple stories about big financial brands actually forcing their folks to use AI. And it's like you kind of get docked if you're not logging in or utilizing it on your workspace every day. They're just trying to push folks to be more comfortable with it. I don't think they care if you're using it to look at some stupid thing. Like it doesn't have to be integral to your service, but it has to be something you're becoming comfortable with every day. So I think that holds value right now.
Yeah, you can't ignore it. That's for sure.
No.
That's for sure. Wendy, great. Always good to end on AI related topics. So I appreciate
I deliver.
I appreciate you joining the show today. Where can our listeners find out more about you, your firm, the great work that you're doing? If they have any questions around IP or how can they connect?
Yeah, love it. Probably LinkedIn is my best place, so they can find me by searching my name, which I assume is in the show notes and right here at the bottom of the screen. The firm website is fkks.com, Frankfurt Kernick Klein and Sells, fkks.com. So that's easy too if folks want to go there. But yeah, LinkedIn is sort of a nice personal place if folks want to connect, follow. I try to post some things that are germane to what I'm thinking about and hopefully helpful for your listeners too.
Okay, amazing. And another way is to like, share, comment on this episode, pass on anybody you think might benefit from our conversation here today. A lot of great information was shared around intellectual property, how you need to understand it, address it, make sure it's protected, get that moat around all the things that are going to provide value to your customer's business, and hit that subscribe button. Make sure to tune in every week for this episode. But Wendy, again, thank you so much for joining today. Really, really loved our conversation and did an amazing job. So thank you.
Thanks, Nick. This was fun.
All right. Take care, everybody. Thank you for joining us on this episode of the M&A Mastermind podcast. And a special thank you to our presenting sponsor, Cornerstone International Alliance. If you enjoyed today's discussion, don't forget to like, share, and comment. We'd love to hear your thoughts. Make sure you hit that subscribe button so you never miss an episode. We'll be back next week with more insights, strategies, and real-life experiences to help you take your M&A game to the next level.